You can all be seated. Give me a moment, please.
Over.
I want to make sure we have all of our judges. Elias?
Yep.
Brian Edmondson?
Here.
Brian. Andrew Waldman?
Here.
Judson Dean?
Here.
Nice to see you.
You too.
Olivia? Oh, Leslie?
Yes.
Lindsay?
Here.
I know Brian Lawler may or may not be joining. We don't have Brian Lawler, right? Okay. If he comes in after the round starts, we will not be counting his ballot. Okay. I think we have the all clear to start.
Justin, this is McDonald v. Shanahan, is that correct?
Yes.
Okay.
All right. Been given the all clear to start. Can I get appearances, please? Starting with plaintiff.
Yes, Your Honor, good afternoon. My name is Patrick McDonald. I'm joined at council table today by Abigail Davis.
Good afternoon, Your Honor.
Good afternoon.
Together, we're here on behalf of the plaintiff, the estate of Samuel Farnsworth.
Good afternoon, Your Honor. My name is Jonathan Shanahan, and I'm joined at council table today by my co-counselor, Mr. Michael Volper. Good afternoon, Your Honor.
Good afternoon.
Today, we represent the defendant in today's case, the city of Philadelphia.
Great. On behalf of the court, thank you for the introductions and congratulations to both of you. Is there anything we need to take up other than a pretrial motion to eliminate before opening statements?
Yes, Your Honor, just one question from the plaintiff.
Go ahead.
During our case in chief, we intend to read pre-admitted evidence, Exhibit 45, onto the record. Would it be okay if my co-counsel assumes the witness stand to read that document?
One moment. That's fine.
Yes, Your Honor.
Nothing from us, Your Honor, other than that motion in limine.
Great. All right, so let's turn to that motion to eliminate. Who's bringing the motion?
We are the defendant, Your
All right,
Honor.
you can proceed.
The plaintiff's complaint should be.
Sorry, and you're welcome to have a seat.
Yes, Your Honor.
Go ahead.
Yes, Your Honor. The plaintiff's complaint should be dismissed as a matter of law because the claims that the plaintiff have raised are barred by the city of Philadelphia's sovereign immunity, which the city has not waived pursuant to Chapter 42 of the Pennsylvania Consolidated Statutes, Section 8521. Now, both parties agree that sovereign immunity, the city of Philadelphia, cannot be sued for tort claims, including negligence, unless a specific statutory exception applies. Now, the plaintiff only cites one exception, the Chapter 42 of the Pennsylvania Consolidated Statutes, Section 8522B4, which relates to dangerous sidewalk conditions. Now, while the defense agrees that the light post in question was public property and it was city-owned at the time of Sam Farnsworth's death, there have been no allegations that there was anything dangerous about the light pole itself, and therefore the exception to sovereign immunity does not apply.
Okay, but aren't there cases where there's no crack in the sidewalk, there's no pothole in the sidewalk, but because it hadn't been cleared of ice and snow, the city was found liable and the exception overcame the sovereign immunity because the conditions had changed to make the city sidewalk dangerous?
That's absolutely correct, Your Honor, and it's a good question. However, there were no snow or ice on the light pole at the time of Sam Farnsworth's death. In fact, the only thing that created that dangerous condition was the act of a third party.
Okay, so do you acknowledge it was a dangerous condition?
We acknowledge that a dangerous condition was created by the actions of a third party, in this case, Laney Davidson. And
Okay.
when a third,
Okay, but the city knew that people might climb the poles, right?
the city could foresee that. However, it's not the intended use of the property. Since there was nothing defective about the light pole itself, and it was a third party that created that condition, the plaintiff can't pierce the veil of sovereign immunity.
Do you have any case law that suggests that intended use is a limitation here?
Yes, Your Honor, one moment. So if we look at Douglas v. Philadelphia Housing Authority, it specifically states that because the dangerous condition arose from a third party's act and not from any defect in the walkway structure, regardless of any maintenance obligations, the walkway itself wasn't inherently dangerous. That means that since there was nothing inherently dangerous about the pole itself, and it was the actions of third parties that they can't pierce the veil of sovereign immunity.
But how do you get past the idea that if snow and ice can render an otherwise safe sidewalk dangerous, and the city could know that there might be snow and ice, and therefore has some duty to clear, how is that any different than when the city knows that that pole may be dangerous because people may be climbing it, and they need to take certain precautions?
That's a good question, and to answer it, we can also look at a specific piece of case law titled Deglamini versus ESM Productions Incorporated. Now, in this case, during a charity bike ride, plaintiff crashed into an unmarked, unbarricaded sinkhole and sued the city. And the city argued for sovereign immunity. Now, the Supreme Court sided with the plaintiff, but they made a specific exception. They said that this decision upheld that municipalities owe a duty to keep highways and sidewalks reasonably safe.
Right, doesn't
for
that case go against everything you're saying?
No, Your Honor. And the reason why is that it specifically stipulates that municipalities have a duty to keep highways and sidewalks safe for intended uses. And it's certainly not the contention of either party that the city of Philadelphia intended for people to climb those poles.
Go on.
Yes. So we can also look at Sydney versus Harmon. Now, in this case, a plaintiff walked into a strip mine highway next to the Commonwealth's strip mine high wall, Your Honor, next to the Commonwealth's highway, and was injured. Now, the plaintiff in this case argued that the Commonwealth should have installed more guardrails for signage.
Which case is this?
This is Snyder v. Harmon, Your Honor.
Continue.
But the Supreme Court held that liability under section 8522B4 does not extend to hazards created by third parties. And in this case, the plaintiff is alleging that the city should have done more, just like in Snyder. However, since the hazard of pole climbing was created by that third party, Laney Davidson, they cannot pierce that veil of sovereign immunity.
Okay, but in that case, there was a question of government inaction. I anticipate the plaintiff's going to argue that this case is a combination of city inaction and negligent action. For example, putting up barriers without testing them. How do you respond if Snyder is only talking about inaction? Do you think the result changes if we're talking also about government action?
Yes, Your Honor. While Snyder does clarify that, if government inaction indirectly facilitated the injury, then the plaintiff may be able to pierce the veil of sovereign immunity. But the Supreme Court still makes it clear in that case that the dangerous condition has to come from the public property itself, not because of the acts of others. What that means is that if the public property itself was defective in design or maintenance, then maybe the public property itself could be dangerous. But if it's a third party that created that dangerous condition, they still can't pierce that veil.
Okay.
Now, furthermore, on that same point, there's a number of cases that make it well settled law that the only physical defects in design, materials, or deterioration of public property can pierce that veil of sovereign immunity. Those cases are Finn versus the City of Philadelphia, Cohen versus City of Philadelphia, and Douglas versus Philadelphia Housing Authority, as we discussed earlier. And all of them establish that sovereign immunity is not waived unless there is a structural defect in the public property, such as a sidewalk, or in our present case, a lamppost. Since there was nothing physically defective about that lamppost in question, nor was the lamppost inherently dangerous itself, sovereign immunity has not been waived in this case, and plaintiff's complaint should be dismissed. Therefore, plaintiff's complaint should be dismissed because it's a matter of law that this type of complaint is barred by the City of Philadelphia's sovereign immunity, which has not been waived pursuant to Chapter 42 of the Pennsylvania Consolidated Statutes, Section 8521.
One more question for you. You said that there's nothing defective about the light pole, and I think that the plaintiff will agree. We'll find out in a moment whether they think there's anything defective about the light pole. But the city put fencing around it, and plaintiff contends that that was dangerous because not only did it fail to keep people out, but it meant that people would be falling, potentially hitting their head on metal fencing, which is what happened here. Isn't that something that the plaintiff has alleged, in the sense that they've alleged that there is actual structure which is defective and dangerous given the environment, that would give plaintiff reason to, in your words, pierce the veil and overcome sovereign immunity?
I think to understand the answer to that question, we have to go back to that idea of intended use. Certainly, neither party is going to argue that the intended use of that fence or that lamppost was to climb up and then fall on the fence. In fact, there's nothing defective about the fence being there. There's no defect in design by putting a fence around the pole. And since the intended use was for that to keep people away from the pole in question, and certainly not to have anyone climb the pole, that means that they still cannot pierce that veil of sovereign immunity.
Thank you.
Thank you.
And you'll have 1 minute for a vote.
Yes, Your Honor.
Mr. McDonald, do you agree this case should be dismissed
No, Your Honor.
on sovereign immunity? Okay, go ahead.
Yes, Your Honor. The sovereign immunity exception under dangerous sidewalk does apply for 3 reasons. First, because the city actively created a dangerous condition on their sidewalk. Second, because they failed to respond when that condition became even more dangerous. And third, because the third-party doctrine cited by counsel under Snyder versus Harmon doesn't apply. Turning to the first issue, that the city actively created a dangerous condition. Pursuant to the Pennsylvania Supreme Court's ruling in Bendos versus White Deer, in that case, the city created a dangerous condition by failing to install a guardrail or sidewalk. And because of that dangerous condition on public real estate, the exception was held to apply. In this case,
Which case is this?
Bendos versus White Deer Township.
Go ahead.
In this case, the city erected a metal fence at the base of every single light post, knowing for a fact that fans of the Philadelphia Eagles would climb the light posts after the Super Bowl. The evidentiary record is clear that when Lanny Davidson fell from the top of the light post, she fell on Sam Farnsworth, who hit his head on that metal fencing that the city put there, knowing that people would climb up.
Okay, but how do you respond to the idea that the intended use of the fence was to keep people away from the pole, not to break their fall?
Yes, Your Honor, this requires a closer reading of the Degliamini case. It does say that the decision upheld that municipalities owe a duty to keep highways and sidewalks reasonably safe for intended uses, but that sentence is severable from the previous sentence, which says that the exception is applied consistently with earlier common law mandates requiring barricades or warnings to protect pedestrians and vehicles. Barriers and warnings are required regardless of whether or not it's an intended use. The second sentence adds on to the previous sentence.
How can you argue that the fence is a dangerous condition when it's not as if, in the absence of a fence, Mr. Farnsworth is going to fall and hit his head on a pillow? It's cement on the sidewalk. How can the fence be the dangerous condition?
Because the fact is, Mr. Farnsworth did hit his head on the fence and that caused bleeding. We don't know what would have happened had he just been fell on by someone and crumpled to the ground on the concrete. He might not have hit his head on a sharp pole like he did in this case. The fact of the matter is, the actual harm he did suffer was caused by the fence. Furthermore, beyond
So is your contention then that the only dangerous condition is the fence and not the pole?
the dangerous condition that the city actively created is the fence.
Okay.
There's another dangerous condition of not maintaining the pole. And that brings us to the second line of argumentation.
Go ahead.
The city didn't actively create a problem with the pole, but they did fail to respond one once understood. They know that very many people tried to climb the poles, and 2 weeks before this case, they decided not to grease the poles for the first time, and the amount of people climbing went up 500%. Yet they made the same exact decision 2 weeks later, therefore negligently failing to respond to a dangerous condition that they were aware of. This also creates an exception under the dangerous condition exception pursuant to Degliamini versus ESM Productions. Because not only is actively creating a dangerous condition allow for the exception to sovereign immunity under Bendos, but failing to respond to one by not implementing adequate barricades or warnings, to use the text of Degliamini, also makes the exception apply.
Okay, but in Degliamini, we're talking about somebody who rode their bike, crashed, and fell into a sinkhole.
Yes, Your Honor.
All of those things relate to the city conditions, right? Whereas in this case, the actual injury came from a third party falling on the plaintiff. Doesn't that seem distinguishable?
This is true, Your Honor. However, the third-party doctrine does not apply. Turning to the case that counsel cited under the third-party doctrine, Snyder versus Harmon, in that case, someone actually left public property, went onto private property, and that's where the harm occurred. And the person complained that there was no barrier telling them don't go on private property. In this case, the dangerous condition that resulted in the harm was on public property the whole time. Furthermore, Your Honor, it was entirely predictable that people would climb up posts. Very many people.
Do you have case law saying that predictability is the factor?
Yes, Your Honor. Turning to the second page of case law, under Kilgore versus City of Philadelphia, a case from 1998, the case emphasized that municipal failure to remove snow or ice remained actionable so long as common law negligence standards, including notice, were met. In that case, the city didn't create the problem with snow or ice, that just happened naturally. But because they were put on notice that there was harm and failed to respond to it, the sovereign immunity exception was still held to apply. The same is true in this case. The city didn't create the problem of people climbing up onto the poles, but they did know about it, and they had actions
Okay.
they could have taken.
I understand, but Kilgore suggests that the standard essentially turns this into a negligence case. But cases cited by Mr. Shanahan suggest that we're supposed to be looking at whether this is a structural defect. I'm looking at Cohen, I'm looking at Finn. These are questions where we're looking at the question of the light pole, the question of the property. How do you reconcile Kilgore with those other cases which seem to go the other way?
Yes, Your Honor. Mr. Shanahan is correct that, for instance, the Cohen case does limit Kilgore and say that it's not just enough that there's snow or ice. There has to be some combination between the harm that was created not by the city and some defect that allows the harm to be dangerous. That's still true in this case. There's a combination between the harm that was created by all the people climbing up onto the poles and some problem that the city created, in this case, the metal fence.
Okay, Kilgore was decided in 1998. I suspect that neither you nor your opposing counsel were alive at the time. Why should I be following that case rather than the more recent cases which support the city?
The more recent cases do not support the city. The only two more recent cases are Cohen versus City of Philadelphia, which does limit Kilgore, but not in a meaningful way for this case, because there's still a combination between a harm that existed that the city was aware of and a harm the city actively created, and both were required. Degliamini, which was cited by opposing counsel, strongly disfavors the city, excuse me. What it says is that the court sided with the plaintiff, interpreting the dangerous condition exception consistently with earlier mandates requiring adequate barricades or warnings. The city put up none.
Anything else?
No, Your Honor.
Okay. The plaintiff's position is submitted. Defense, would you like to rebut?
Absolutely, Your Honor. May I begin?
Go ahead.
Specifically to the point that Mr. McDonald just brought up about Degliamini. Mr. McDonald said that the city failed to put up any barricades, which we know is simply not factually true in this case. The city specifically put up fences around the poles. That's a barricade, Your Honor, and Degliamini says that it upheld that municipalities owe a duty to keep highways and sidewalks reasonably safe for intended use. And no one can argue that anyone from the city government intended for people to be climbing these poles. Now, Mr. McDonald also cited Bendas v. White Deer. However, that case also emphasized that immunity only doesn't apply when the municipality negligently fails to install or maintain protective features like guardrails or sidewalks needed to make the real estate safe for intended use. Now, in this case,
So you've hung your hat on intended use. I look back to Mitchell v. Rochester, recognizing that case was decided before the Sovereign Immunity Act. But nonetheless, it talks about a duty that municipalities have when it comes to foreseeable pedestrian use. Surely you'd acknowledge that in Philadelphia, people climbing these poles is foreseeable to the city, right?
I would agree, Your Honor. And Mitchell v. Rochester goes on to say that the municipality has a duty to maintain the streets in a reasonably safe condition for foreseeable pedestrian use, including erecting safeguards when necessary. The city of Philadelphia did erect safeguards. They put fences around the poles to try to keep people away from them. However, it was a third-party act that ignored those safeguards and created a dangerous condition.
Anything else?
No, Your Honor.
Okay. I appreciate the arguments of both counsel. After careful consideration and considering the desire that we're going to have an entire trial, I'm going to deny the defense's motion, and you're free to re-raise that on appeal.
Yes, Your Honor.
Okay. All right, I'll give you a moment to catch your breath, and then we'll get started in just a second. Okay, Mr. McDonald, you ready to go?
Yes, Your Honor.
Okay, you can proceed. The record is open.
May it please the court. Counsel. The city chose to save money instead of a man's life. Members of the jury, today you'll hear about a young 23-year-old man named Sam Barnesworth. You'll hear that he died at this city's Super Bowl after party in February of this year. From risks that city officials knew about. That after big wins, Eagles fans climb up onto the top of street lamps, and the fans can fall down. Members of the jury, as you listen to the evidence today, I'll ask you to pay attention to 3 risks that the city created that caused Sam's death. The light posts, the ladders, and the landing zone. It's February 9th, 2025. Right outside the doors of this building in Center City, Philadelphia. The Eagles have just won the Super Bowl and the atmosphere is electric. Crowds are rushing through the streets, music is blasting, fireworks are heard overhead, and a young Eagles fan named Sam Farnsworth is right there in the middle of it. His team's just won. He's smiling, brimming with excitement, pumping his fist. And then Sam and his friend Lanny Davidson see one of those light posts that Eagles fans always climb. They go to check it out. Sam says, "Hey, doesn't the city normally put grease on the light posts?" Lanny says, "Yeah, I don't see any either. Maybe we can go up and climb." So they look for a way to get up. And they see a metal fence right at the base of the light post. The city has put a ladder there for them to climb up. Lanny climbs up onto the fence and then up onto the pole. It's easy. And Sam waits underneath. You'll hear that just half a block away. A city police officer is watching everything unfold. He sees the fans climbing the light posts. He sees them using the fences as ladders. But he makes a decision not to clear the landing zone. He doesn't go over and tell Sam to move, doesn't move the fan away, doesn't clear the metal fence that's standing right there, doesn't tell Lanny to stop. Instead, he panics. He rushes back to the base of the pole and yells up, "Get down now!" With Sam and the metal fence right underneath Lanny. You'll hear that decision took a dangerous situation and turned it into a catastrophe. Because at that moment, Lanny slips, falls, hits Sam on the head, he crumples to the ground, and Sam strikes his face on the metal pole that's still there. It bleeds out. Members of the jury, today you'll hear that the reason the city didn't put grease on the poles, the reason the city put the fences that acted as ladders at the base of them, and the reason they didn't hire enough police officers to clear the landing zones is because of the cost. You'll hear that the city chose to save money instead of amassing. And that's why you're here. Because when our city officials make decisions that unreasonable, and when someone gets hurt, it's against the law. Today, we have a burden to prove to you 3 elements by a preponderance of the evidence, meaning more likely than not true. That the city's actions were unreasonable, that Sam suffered harm, and that the city's unreasonable actions caused that harm. And we're going to prove those elements to you by showing you the 3 risks the city created that caused Sam's death. The light posts, the ladders, and the landing zone. First, Miss Lanny Davis, Sam's friend, take the stand and tell you that the city didn't do what they always do for the Super Bowl this year. They didn't grease the poles, meaning climbing up was easy. She'll tell you that instead of greasing the poles, they put a metal fence at the base that made it easy to climb up because she could use it as a ladder. And then the city's director of public safety, Ms. Walter Edwards, will be forced to admit that that metal fence was at the base of the pole when Sam died, and that he passed away because he hit his head against it. She'll tell you that the reason they didn't hire more officers to clear the landing zone, to move the pole away, to tell Sam to get out of harm's way, is because of the cost. Folks, this is a case about a city that knew better. That knew that they could take steps to avoid the danger, but chose not to because they didn't want to pay for them. This city chose to save money instead of the man's life. And that's why at the end of trial, I'll ask you to find the city of Philadelphia liable. Thank you.
Thank you, Council.
Everson.
You may.
Rules only work if you follow. Wear a helmet. Buckle your seatbelt. Look both ways before you cross the street. These are all rules that exist for a reason, folks. And it's to keep people safe. Because if someone doesn't follow one of these rules, people can die. Now, everyone in Philadelphia knows that when the Eagles win a big game, the fans in this city go wild. They take to the streets, they start celebrating, and sometimes celebrate too hard. And that's why the city of Philadelphia has a rule it consistently urges its people to follow. Don't climb the poles. Sounds like a simple rule. And in court today, you're going to hear that it was a rule for a good reason. But the plaintiff's friend, Lainey Davidson, broke that simple rule. Now, make no mistake, folks, what happened that night to Mr. Farnsworth was a tragedy. But we're in court today because it's a tragedy that was avoidable. See, Mr. McDonald just told you that this could have been avoided if the city had acted differently. But the problem is, he's only showing you one side of the coin. In reality, the law tells us that Lainey Davidson also had a duty to use ordinary care. That means that she still had to act like a reasonable person would to avoid hurting herself or others. That's why we as a defense, we brought forth an affirmative defense today. That means that we have to show it's more likely than not that Lainey Davidson should have foreseen the dangers of climbing that pole, but did it anyways. Now, this trial, it's a search for the truth, folks. And as members of this jury, you all get to decide what that truth really is. And I know that sounds like a difficult job, but the best tool you have is your common sense. So as you're listening to all the testimony throughout today's trial, ask yourself, did Lainey Davidson use her common sense that night to avoid danger? Did she act like a reasonable person should to protect the people around her? To help you answer that question, we're going to show you 3 key facts in trial today. First is that the city of Philadelphia was adamant about the fact that people shouldn't be climbing those poles. You're going to hear from the city's Director of Public Safety today, Mr. Walker Edwards, and he's going to tell you about all of the announcements and warnings and precautions that he took to tell people you shouldn't climb. That brings me to the second point, that the evidence will show that Lainey Davidson knew climbing that pole was dangerous and did it anyways. You see, you're going to hear from Ms. Davidson in court today, and she's going to tell you she was well aware that just 14 days before the Super Bowl, when the Eagles won the NFC Championship, another man had died when he climbed up a pole and fell to the ground. That brings me to the third point, that's why Sam died. See, you're going to hear that when Lainey Davidson got to the top of that pole, she slipped and she fell directly on Mr. Farnsworth. If she didn't make the decision to climb that pole, this never would have happened. And you're even going to hear in court today that Mr. Farnsworth explicitly told her not to climb that pole, and she still did it anyways. Now, I want to be really clear here, folks, because the plaintiff still has a burden in today's case. They still have to prove to you that it's more likely than not that it's the city of Philadelphia's negligence that caused Mr. Farnsworth's death. But even if you believe in the plaintiff's case, that's still not enough to return a verdict in their favor. Because you're still required to consider Ms. Davidson's own negligence to that of the city of Philadelphia. And if we find that Ms. Davidson's negligence was a greater factor than Mr. Farnsworth's theft, even if you find it was an equal one, then you must find the city not responsible. That's why at the end of trial today, I'm gonna stand before you again and ask you to do just that. And when I do, I want you to remember your common sense. And remember, the rules only work if followed. Thank you.
Thank you, counsel.
Your Honor, may we call our first witness?
Go ahead.
Thank you. The plaintiff calls Lanny Davidson. May I proceed?
Yes.
Good afternoon, ma'am.
Good afternoon.
Can you please introduce yourself to the members of the jury?
Hi, my name is Lanny Davidson.
Can you tell us a bit about yourself?
I was born and raised here in Philly. I live in LA right now. I'm a 2L at UCLA Law.
Ma'am, could you tell the members of the jury what happened on February 9th of this year?
It was the Super Bowl. I've flown back home to watch the Eagles play the Chiefs. And I was with my best friend Sam. Behind the light pole. So. He died.
Ms. Davidson, why did you climb that light pole?
I don't know. I'm an Eagles fan. Since the day I was born, the first onesie I got was an Eagles onesie. And then every other celebration I've been to, I've seen fans do it, but the poles were always greased with this stuff to make it slippery. And then on the Super Bowl Sunday, there were these fences around the poles that I figured I could use to climb on.
Ma'am, I want to break a couple things you just said down. And I want to talk about a light post, a ladder, and the landing zone. Let's start with the light posts themselves. Have you ever seen city officials doing anything to the light posts downtown during a sports game?
Yeah, in 2018, 2023, and 2022, all when Philly teams won the games, I've actually saw police officers take grease and put it on the poles to avoid fans from climbing them.
Did you ever go downtown when there was grease on the poles?
Yes, back in 2022.
Did you climb the poles when they had grease on them?
No. I mean, it was there, it's slippery. I don't even know if I've been able to climb them.
What about Super Bowl Sunday this year? Was there grease then?
When I saw the pole, I even went to check if there was any grease, and there wasn't, so I figured it would be easy to climb.
Was it?
Yeah, I stepped on the metal fence that was there to boost myself up and climb.
Now that we've talked about the light posts themselves, I want to discuss whether you had a ladder or anything to help you get up. You mentioned a metal fence. Where was that?
Right around the post itself.
Would you recognize a picture of the metal fence if I showed it to you?
Yes,
Your Honor, I'm approaching opposing counsel on the witness in turn with plaintiff's proposed exhibit 35.
Go ahead.
Approaching counsel. The witness. You're welcome. Would you all like a courtesy copy?
I have one. Thank you, though.
Ms. Davidson, don't show that to the members of the jury just yet, but could you describe what you're looking at?
it's 4 pieces of metal fencing put together around a light pole. It's not the light pole I climbed, but it looks just like the fence that was there.
Your Honor, the plaintiff offers exhibit 35.
No objections, Your Honor.
35 is admitted.
At this time, I'll publish a copy to the members of the jury. Ma'am, using exhibit 35, could you explain to the members of the jury how you were able to get up on that light pole?
It wasn't very high, so I actually stepped onto the top here, leaned onto the pole, and just climbed up.
Hold up, are you saying that you climbed over the metal fencing into the enclosed area and then straight up?
No, sir. I used the metal fence to boost myself up.
Now that we've talked about the light posts themselves and how you got up, I want to discuss the landing zone, what was underneath. When you climbed up, were you able to see down?
Yeah, that was about. I now know 18 feet up. And when I looked down, I saw Sam right underneath me.
Besides Sam, did you see anything else right underneath you?
The metal fence.
What happened next?
I got to the top. I looked down, I saw Sam, and I tried to start climbing down. And I fell.
What'd you land on?
It was an accident. I landed on Sam. His head fell right into the fencing, and I looked down. It was the most blood I've ever seen in my entire life. He wasn't moving. I started shaking him, and he wouldn't even open his eyes. I didn't know what to do, so I just started screaming.
And when you were at the base of the pole after falling, did you see any police officers then?
Once I fell, officers came.
How long after did an officer come?
Not long. I mean, it was pretty soon. It wasn't long after I fell that the police officer came there to hold me off Sam, and then paramedics arrived.
You said, I'm sorry, man.
Paramedics came and Sam left in a body bag right there at the scene.
Davidson, I'm so sorry for your loss. You said a moment ago that an officer arrived pretty soon. How sure are you on the timeline? How sure are you about that?
I'm confident it was pretty soon, but it was just, it was terrible.
When was it that you decided to climb up the light post that day?
When I realized that there wasn't any grease on the poles.
How'd you get up?
I used the city's fence that they had put there.
You said that a police officer arrived pretty soon after you fell. Did the officer clear Sam or the fence out of the way?
No. I fell on Sam, and Sam hit the city's metal fence. They had just greased the poles. I wouldn't have gone.
Davidson, thank you for your time. There are no further questions.
Thank you, counsel. Cross-examination?
Yes, Your Honor. Ms. Davis. You're an Eagles fan, right?
Pardon me?
You're an Eagles fan, right?
Of course,
So is your friend, Mr. Farnsworth.
the biggest.
And since you were the biggest Eagles fans, you decided to watch an Eagles game on February 9th, right?
Not only that, we actually decided to fly to Philly to watch it. We wanted to go to New Orleans, but we couldn't afford it.
That's right. You flew into Philadelphia to watch the Super Bowl, Mr. Farnsworth. Isn't that right?
Yeah.
And we can all agree that the Super Bowl, that's as big as a football game can get, isn't it?
Especially in Philadelphia.
And since you were in Philadelphia and you were watching the Super Bowl, you decided to start drinking.
Yeah, Sam and I drank that day.
In fact, you watched the football game at a bar.
Yeah, McGillen's, it's a couple blocks that way.
And right after the Eagles won the Super Bowl, that's when you took to the streets to start celebrating. Isn't that right, Ms. Davidson?
Yes.
And while you were celebrating, you saw a pole, didn't you?
Yeah. Decided to climb one.
And that pole, it's the one that's right outside this courthouse at 12th and Chestnut.
Yeah, right over there.
And once you saw that pole, you decided to do something that you think is crazy.
I decided to climb the pole.
And you think climbing that pole is crazy, don't you, Ms. Davidson?
I almost fell over the passage, right? The whole celebration in Philadelphia is crazy. I thought it would be okay.
Ms. Davidson, I'm just asking you to confirm what you thought about climbing that pole, and you thought it was crazy, isn't that correct?
Yeah.
Not only that, you think it was stupid.
Now I don't. I mean, if I could take it all back, I never would have done it. I didn't think that would happen.
So that's a yes, you think climbing that pole is crazy and stupid?
Now, absolutely.
And despite thinking it was crazy and stupid, you decided to climb that pole.
Objection, Your Honor, asked and answered. We've been over the fact that you climbed it a couple times already.
Your Honor.
I'll give you the same leeway when you cross examine.
Yes, Your Honor.
Overruled.
Now, Ms. Davidson, you're also well aware that just 2 weeks prior, someone died climbing a pole, right?
Yes, I wasn't in Philadelphia at the time, but I was there.
And you knew that someone had died climbing a pole before you made your own decision to climb a pole, right?
Yeah, but in the past, Philadelphia had greased the poles, so this time they have.
Ms. Davidson, that wasn't an answer to my question. What I asked you was, you still decided to climb the pole, even though you knew someone had died, right?
Yes,
All right, so you decide to climb it. You don't just walk right up to the pole, do you?
that's right. Yeah, the fence was there.
That's exactly right. There was a metal fence surrounding the pole. Isn't that right?
Yes,
Ms. Davidson, we can agree that the point of a fence is to keep people away from things, right?
Yeah.
But you still decided to just climb right over the fence.
I actually climbed on top of the fence.
I'm talking about when you first entered into that enclosed area, you first climbed into that area, right?
Into it and then on top to get up.
That's right. We agree that after that, you went on top of it. I'm talking about before you did that, Ms. Davidson.
Yes, I stepped over it.
All right, and so you step over the fence, you look up at it, right?
Yeah.
It's an 18-foot tall lamppost.
Yeah.
And you were drinking,
I had earlier in the day.
and so you decided you were gonna climb that 18-foot tall, 18-foot tall light post, right?
I did.
Now, as you're climbing up that lamppost, you look down, don't you?
Yeah.
And you see that Sam Barnesworth is right below you.
It was.
But you still kept climbing, didn't you?
I did.
Even though Mr. Farnsworth standing right below you was telling you to stop, right?
He had told me to stop once and then when I got to the top, I looked down at it.
And despite the fact that Mr. Farnsworth told you to stop, you didn't, right?
No,
So you get to the top of the pole, and that's when you slipped.
I was at the top and then once I tried to go down was when I slipped.
And when you slipped, you landed right on Mr. Farnsworth.
Yes, and I'll never forgive myself for that.
That's right. You will never forgive yourself for choosing to climb that pole. Isn't that right, Ms. Davidson?
I'm here and Sam's not, and that's not right.
Thank you, Ms. Davidson. I have no further questions, Your Honor.
Your Honor, we have no redirect examination, and Ms. Davidson stepped down.
Yes.
And permission at this time for Ms. Davis to assume the witness stand to read out a couple excerpts from the DevNet report.
Yes. Will you give us the section numbers and refer to the lines? That way counsel has a chance to raise an objection before the jury hears it.
Yes, Your Honor. It'll be the entirety of
Sorry,
section.
is this document already in evidence?
Yes, Your Honor.
Okay, so then I don't think we'll hear any objections. You can go ahead and just read portions you want.
Sounds good.
Go ahead.
Ms. Davis, could you read section 4, including the title for section?
The decisions concerning the fencing were negligent. The fences in question were short enough that almost any adult or teenager could easily climb over them. This was barely a deterrent. Moreover, the city appears not to have considered if metal fencing near the light poles was itself a safety risk, given the possibility of people standing on the fences or falling from the light poles.
And could you read the sixth section, including the title?
The city's negligence caused or contributed to Farnsworth's death. If better fencing had prevented Davidson from reaching the pole, if police had prevented Davidson from climbing the pole, if grease had been used to prevent Davidson from reaching the top of the pole, or if the city doesn't have metal fencing for Farnsworth to strike his head against, then this accident would not have happened.
Thank you, Ms. Davis. And with that, the plaintiff rests her case in chief.
For context for the jury, this is the expert report of the plaintiff's witness who is deemed unavailable for purpose of trial. You should consider that evidence like all other evidence.
May I have permission to publish a copy of Exhibit 45?
Yes? Okay, and you said you rested, is that right, Mr. Wynn?
Yes, Your Honor.
Okay, great. Vince, do you have any witnesses?
Yes, Your Honor. At this time, the defense calls Walker Edwards to the stand. May I proceed?
Yes.
Good afternoon, Mr. Edwards. Could you please tell us a little bit about who you are and what you do?
Sure. Hello there. My name is Walker Edwards. I work as the Director of Public Safety for the city of Philadelphia.
And as the Director of Public Safety for the city of Philadelphia, what are your responsibilities?
Oh, it's to keep the city safe. Usually that means things like parades, major sporting events. I'm the one making the decisions to keep our citizens unharmed.
Did you go to school for this?
Yes, I did. Way back in the day, I went to UCLA for my bachelor's in criminal justice and urban planning. And then I got my master's at Drexel.
In that case, I'm going to talk about what happened on February 9th of 2025. Were you in charge of city safety that night?
Yes, of course.
And could you tell us what was happening on February 9th, 2025?
Sure. I mean, it was the Super Bowl, Super Bowl 40.
Now, Mr. Edwards, were you concerned about any safety risks that you thought might come into play that night?
Of course. Look, we're in Philadelphia. We were worried that if the Eagles won, knock on wood, that people would spill out into the streets and chaos would start.
Were there any specific things you thought may have happened in that chaos?
Of course. In the past, I'd seen cars flip, windows punched out, fires lit. And we've seen people climb the lamp posts that line the side of the road.
You just mentioned that you've seen reports of people climbing those lampposts. For the Super Bowl this year, did you take any precautions to make sure people wouldn't climb those poles?
Yes, of course.
Could you tell us what they were?
Sure. We had a massive police presence around. We put up a fences to stop people from climbing those posts. And we ran a massive PR campaign telling them not to do it.
I want to take those one by one. Let's start with that police presence you mentioned. Could you tell us why you had police stationed in Philadelphia that night?
Sure. Well, it just makes sense. With police officers there, hopefully, they can monitor the situation. And if anybody starts climbing the poles, tell them to get down from there.
How many police officers did you have in the city?
Well, it was quite dense. We were looking at about 40 for every 2 blocks.
In that case, I want to talk about those fences you mentioned. Why'd you put fences around the lampposts?
Well, the idea was to stop people from climbing them. Look, if you see a fence, that's not exactly an invitation to come inside. That was the idea. It was to show them, well, it was not to be played with.
And finally, those announcements that you mentioned. What kind of announcements were you putting out?
We were telling people not to climb the poles.
And where were you putting these announcements out?
All over. They were public announcements. We put them on the news, in social media. We were basically shouting it from the rooftops.
You just mentioned you put it on social media. Would you recognize one of the social media posts if I were to show it to you?
I'm sure, yes.
Your Honor, let the record reflect, I'm approaching opposing counsel, the bench, with witnesses heard with exhibit 33. Your Honor, like courtesy copy.
I have one, but thank you for asking.
Here you go.
Thank you.
Now, Mr. Edwards, what did I just hand you?
This is a social media post. It's one of those warnings we were talking about as part of the PR campaign.
Does this picture of that post fairly and accurately depict the post as it was when you last saw it?
Absolutely. It looks right as rain.
Your Honor, this time we'd like to enter exhibit 33, the evidence.
Objection, Your Honor, to hearsay. There are several statements on the right-hand side of the document, up to and including the like count, which could be used to indicate, for instance, the truth value of how many people saw it.
I'm finding the exhibit. Okay, response?
Yes, Your Honor, we're not actually concerned with any of the statements that are on that right-hand side, that being the caption or any of the comments. We're completely amenable to redacting all of those and just keeping the image itself with the words at the top, which are commands.
Okay, so I'm looking at the right side. There appear to be 4 messages. First, it says original audio. I assume you have no problem with that.
No, Your Honor.
Second is the message from the city, don't climb the light poles. The mayor has a special message. Do you object to that?
No, Your Honor.
Okay, so you're only concerned with the 2 responses. And it sounds like both parties are amenable to just striking that.
That's
Or
correct,
redacting
Your
that.
Honor.
Okay.
We're
So-
good with that, Your Honor.
Great. So exhibit 33 is received with the redaction of the comments made by Lady Fox 40 and T Winning. All right, you can proceed.
Yes, Your Honor. Now, Mr. Edwards, could you tell us who is making this announcement?
Right. This is the mayor, my boss, Rachel Holt.
Do you see the mayor of Philadelphia, Rachel Holt, in the room with us right now?
Objection, Your Honor, relevance.
Counsel?
Your Honor, the bar for relevance in this case, in this jurisdiction is very low. For something to be relevant, it just has to make, and it just has to have any tendency to make a fact in this case more or less likely. Now,
Where are you going with this?
we're exploring what the message that the mayor, Rachel Holt, said, and letting the jury see the person who actually said that message certainly has probative value.
Your Honor, they know the mayor. She's the mayor of the city. She's also on the document, pointing out whether or not she is or in the room. I don't know what purpose that's being used for. It could be used for a 404 purpose. I'd ask for a proffer from counsel.
Okay, here's what we're gonna do. I think that given the fact that we have somebody in the room who is here as a spectator, I'm assuming that's who you're gonna be pointing to.
Yes, Your Honor.
I think it breaks the 4th wall, but I don't think this is a violation of a rule or anything like that. So what we're gonna do, I'm gonna do is I'm gonna say, we're gonna skip this question, continue asking about the mayor. I'm gonna instruct the jury not to score up either side, up or down as a result. We're just gonna strike that from the record.
Yes, Your Honor.
Okay, go ahead.
Yes, Your Honor.
Go ahead.
Now, Mr. Edwards, could you please tell everyone what the mayor of Philadelphia told the residents to do?
Sure. She says it right here. It says, attention Philly, don't climb light poles.
Thank you. I have no further questions, Your Honor. Let the record reflect. I'm publishing exhibit 33 to the jury.
May I proceed with cross, Your Honor?
Go ahead.
Thank you. Good afternoon, sir.
Good afternoon. How are you?
I'm doing all right. How are you?
I'm like 6.
Sir, I want to discuss what Philadelphia fans typically do after a big sports win.
Okay.
Because you told us that fans typically go on the streets, right?
Oh, yes, they do.
Lots of them, right?
Very many. Yes.
Super Bowl this year, you were expecting 100,000, sure.
Right.
And typically, they climb the light poles after a big win, sure.
Yes, that happens quite often.
Happened all the way back to 2008, right?
Right. Those were the first reports we received.
You've known about it for 17 years by this point, sure.
Yes, that sounds right.
I want to talk about what the city typically does in response to people climbing the light poles. Because in 2018, you started greasing the poles, true?
Right. And that means we started putting a slippery grease to make it harder to climb.
All right. The first game you did that was for the 2018 NFC Championship Series, right?
Right. That's kind of like the Super Bowl qualifier.
All right. In that game, you received, what was it, 10 reports of people climbing the light poles, right?
Exactly. This was 10.
I'm gonna write down 2018 and then 10. If at any point this doesn't reflect your testimony, just let me know.
Thank you.
The second game you greased the poles, that was for the 2018 Super Bowl, true?
Correct.
And for that game you received, what was it, 12 reports?
12 is exactly true.
Okay. You greased the poles for that game too, right?
Yes, very slim.
All right. Third big game, that was the 2022 NLCS, right?
Correct.
All right. And for that you received, it was 15 reports?
12, 15, I think.
12 or 15, sir?
I think it's 12.
Oh, okay. And then the 2023 NFC Championship, you greased it again, right?
Exactly. That's where we had 15.
Okay. So a total for these 4 games of, if I'm doing the math right, looks around 45, would you say?
I'm so sorry. 40, 47? 47.
All right. 47 for those games. And then earlier this year, you decided to not grease the poles, right?
Right. So we saw that whether we greased or not, people were still climbing. So our idea was if they were going to climb anyways, well, you might as well make it less slippery. But yes, you're right.
Okay. So that was the 2025 NFC Championship game, right?
Bingo.
2025 down here. For that game, sir, you didn't receive 10 reports of people climbing the poles, did you?
No, the number was 75.
Hold on. 75 reports of people climbing the poles?
Yes,
That was the time when you didn't grease them, right?
yes, it's true.
2 weeks after that game was the Super Bowl this year, right?
Yes,
You decided not to grease the poles again. True?
that's right.
Sir, I want to talk about why the city might have made that decision. Because the fact is, greasing the poles, it's expensive, wouldn't you say?
Well, it costs some, but per pole, it's not that much, no.
You gotta pay for the grease,
Yes, you pay for the grease.
cost of labor,
You gotta put it up.
gotta clean it up.
I take it back.
Sir, all in all, that costs around $10,000, right?
Right, $10,000 for the city.
When you didn't grease the poles for the 2025 Super Bowl, that was when Sam Farnsworth lost his life. True?
Right.
And sir, the fact is, it's not just that the number went up. It's that someone got hurt when you didn't grease the poles the first time. True?
Right, well, somebody died, yes.
For this game, in 2018, the NFC Championship game, how many reports of people getting hurt from climbing the poles did you have?
Well, in none of them, from 2018 to 23, did anybody die.
For 5 years, you didn't have any reports of anyone getting hurt from climbing the poles, right?
But yes,
But then in 20,
Can you just move back so I can see it as well?
yes, Your Honor, my apologies. Is
That's okay.
that all right?
That's great. Can the jury still see it? Okay, go ahead.
But then in the NFC Championship game this year, it's not just that someone got hurt, someone died, right?
yes, of course.
Let's move on from talking about the light posts themselves and discuss the landing zone beneath them for just a moment, if that's okay.
That works for me, yeah.
You've reviewed a copy of a report that a police officer made about Sam Farnsworth's death, right?
Yes, I certainly have.
Would you recognize it if I showed it to you?
Oh, I think so.
Your Honor, approaching counsel and the witness with exhibit 6. Approach the witness.
Oh, thank you.
You're welcome. Your Honor, I'm guessing you have a courtesy copy. Sir, this is the report that we just discussed, right?
Yes,
You read the whole thing before?
I have.
Looks fair and accurate?
Looks fit as a fit.
Your Honor, the plaintiff offers exhibit 6.
We have an objection to hearsay within hearsay, Your Honor. May I be heard?
Yeah, let me find the document. Go ahead.
Your Honor, this police report in its entirety is hearsay. However, what we're more concerned with is in the narrative summary, the police officer refers to the statements of other people, which is also hearsay.
Can you direct my attention to those portions?
Yes, Your Honor, it should be at the end of the narrative summary. It talks about how other witnesses confirmed what was said. That's an outward statement from other witnesses. It's being used for the truth of the matter asserted.
So-
And as such, it's inadmissible.
Okay, I just want to make sure I know what you're objecting to. So it seems like you're objecting to everything from the phrase after the accident, I tried to interview until the end?
Yes, Your Honor.
Okay, so we're talking about statements from Davidson, the decedent's family and onlookers, is that right?
That's correct.
Okay, Mr. McDonald?
Yes, Your Honor, we're not using any of those for the truth of the matter asserted. If counsel has a specific concern, we could go into that. Furthermore, even if we were, they would fall under 801D2B because one of our party opponents, an officer of the city in this case, and the court has already ruled that this person, Officer Jones, is party opponent under 801D2, has adopted that, manifested that they believe it to be true by including it in their report.
Your Honor, if I may.
Yeah, why don't we take these one at a time? So the first one is the statements. Okay, actually, Davidson doesn't even make any statements, right? Davidson's just crying inconsolably. Is that right?
Yes, Your Honor.
Okay, so we're really just concerned with statements of Farnsworth's family and the dozen onlookers. So we'll take those one at a time. The statements from Farnsworth's family, Mr. McDonald, why are those not inadmissible hearsay?
We're not using those for the truth of the matter. If counsel would like to redact them, we're okay with that. We're just not going to refer to them.
Okay, so do we have agreement then to redact?
Yes,
Great.
Your Honor.
And then the last of these statements from the dozen onlookers, Mr. McDonald?
We would like that in if, because it would fall under 801D2B, that this officer has manifested that he believes them to be true, just confirming his own, what he actually saw during the matters of the report.
Your Honor, if I may, that is not how that specific rule of hearsay works. Just because it says that other people confirmed what he saw, doesn't mean he's manifesting their statements to be true. This says that a dozen onlookers who witnessed the accident all had the same observations I had. That specifically refers to statements that other people were making to the officer at the scene, which is inadmissible hearsay.
Okay, I'm gonna agree with the defense on that point. We're gonna strike the two paragraphs, I mean, they're 2 sentences or so each, just the 2 paragraphs at the end from I called to photos of the accident. Okay, but otherwise exhibit 33 is admitted. Exhibit 6 is admitted. You can proceed.
Sounds good, Your Honor.
Yes, Your Honor.
Mr. Edwards, let's go back to the landing zone beneath the light posts. Because in this report, Officer Jones, he's a city of Philadelphia police officer, right?
Yes,
Describes seeing the moment when Sam Farnsworth dies, right?
right, he does.
Sees Lanny Davidson up on the pole, true.
Yes,
Sees Sam Farnsworth down at the bottom, right?
that's you.
Describes seeing the metal fence inside the pole, true.
Yes, he does.
And he says that Sam Farnsworth was standing inside the metal fence, true.
Right, when he died, that's true.
But the officer doesn't say that he brought a ladder so that Lanny Davidson stepped down, right?
No, nothing about a ladder, no.
Officer Jones didn't go over and tell Sam Farnsworth to leave, right?
Sam Farnsworth? No,
Didn't move Sam out of the way.
no,
Didn't move the metal gate at the bottom out of the way of the person on top, right?
no. He went over and he told the person on top of the pole to get down.
He said he told the person on top. The exact word Officer Jones uses is, I yelled at the person, right?
I'm sorry, could you point me?
The second full paragraph, sir.
I got it. I yelled, get down.
This is the police, I'm ordering you down now, right?
Right,
So the officer didn't go up to the pole and say, hey, stay there, there's someone right beneath you, right?
no, he said you have to get down.
Didn't say, stay there, there's a metal gate still beneath you, right?
No,
No, the officer yelled, get down now, right?
right,
That's when Lanny Davidson started to descend, true.
right. Well, that's when he started coming down. Yes,
Miss Davidson slipped, true.
she did.
And she fell on Sam and the gate, true.
Right.
Thank you, sir. Your Honor, I have nothing further. Now, I'm going to approach you to retrieve the document.
That's to you.
Thank you.
You're welcome.
Can I have both counsel approach for a moment, please?
Yes, Your Honor.
So I understand. You didn't say no. So I can do a couple things. I can just let them know that it's the case. I can let him know that it's the case, let him correct. I'll certainly about them that they did it wrong. So do you want to redirect them or do you want to know? That's hard. We can move on. You're great. You can step back. Okay, you're gonna see a redirect examination in a moment. I wanted to have them approach because defense counsel had received a ruling before trial that he could ask about the mayor being present because the character of the mayor was based on one of the coaches in the competition. And so I should have let him do that, but also plaintiff counsel didn't know that he received that ruling ahead of time, so he did nothing wrong by objecting. So they did nothing wrong, fault is on the court. Don't score anybody down except you can yell at me. Okay, Mr. Shanahan, redirect examination.
Yes, Your Honor. Now, Mr. Edwards, do you recall being asked about how you previously greased those poles?
Yes, I do.
So were you greasing the poles in all of the major sports wins prior to 2025?
Right. Every single one on that chart, 2018, 2018, 2022, 2023, I grease them every time.
When you were greasing the poles, was the number going down over time?
Well, no, you can see it with your own eyes. Before we started greasing, we were only getting a handful of clients. Then we start, and it goes 10, 12, 12, and then 15. It was increasing the more that we grease.
So could you explain for everyone in the room why you stopped greasing those poles?
Yes, we saw that when we greased, people were still climbing. More people were climbing. But we figured if they were going to climb anyways, we might as well reduce the harm by making it less slippery. Maybe they wouldn't be as likely to fall.
Thank you, Mr. Edwards. I have no further questions, Your Honor.
Thank you, counsel.
No recross examination, Your Honor.
You can step down. Thank you. Mr. Shanahan?
Your Honor, this time the defense rests its case in chief.
Would parties like a minute to collect their thoughts before closing?
We're okay with that, Your Honor. Before we do go into closings, we'd move to preserve the whiteboard as plaintiff's exhibit A.
Any objections?
Your Honor, plaintiff is certainly allowed to refer to it during his closing arguments. However, this shouldn't be entered into an exhibit for the jury to see in the deliberation.
Okay, I think that's what counsel asked for, just to preserve for use in closing, but not as an admitted exhibit that the jury can have after closing.
That's completely
Okay.
fine with us, Your
And
Honor.
both of you are allowed to use it, so it's preserved, so nobody can write on it, change it, etc.
Just with one question on that, may I change the 47 to a 49? It looks like we may have got the math wrong in the heat of the moment. Sorry.
Yes.
Thank you.
As I showed everybody earlier, we all make mistakes. So you can go ahead and change that to a 49.
Yes, Your Honor.
And then you can proceed whenever you're ready.
Yes, Your Honor. Please the court. Members of the jury. The city chose to save money instead of a man's life. When our government officials are warned, clearly, urgently, repeatedly, that the streets aren't safe after a big game day, we expect them to take action. When there are risks they know about and solutions they should know will work, we expect them to prioritize human life. Not protect the budget, not assume it will be safe, not hope for the best, but protect human life. That's the duty that this city ignored. Because when they were shown convincing evidence that there was a dangerous condition on their streets, they did nothing to make it better, and instead took steps to make it significantly worse. That's why Sam's family has brought a suit of negligence against the city. Because there were 3 risks they created, 3 risks they knew about, 3 risks they ignored. And those risks led to Sam's death. We show you them today. The light posts, the ladders, and the landings. Today we have to prove to you three things by a preponderance of the evidence, which means more likely true than not. That the city acted unreasonably, that Sam suffered harm, and he certainly did, we know he passed away, and that the city's unreasonable actions resulted in that harm. And the way we proved that to you was by showing you that they knew that the light posts were dangerous. They should have known that they were putting up ladders and that they knew they didn't have enough police officers to clear the landing zones. They knew all that but failed to respond. That was unreasonable and it resulted in Sam's death. So in the minutes remaining, what I want to do is I want to walk through each of those three things. And we'll start with the light posts. Because you heard today that the city had a tried and true strategy to deal with the problem of fans climbing the poles. They put grease on them. In 2018, they put grease on them. They got 10 reports of climbing and then 12. In 2022, they put grease on them. They got 12 reports of climbing. In 2023, they got 15 reports of climbing. Think back to just a moment ago. Mr. Edwards was on the stand. He told you, oh, we saw this increase in the amount of people climbing the poles. It went from 10 all the way to 12, and then it stayed at 12, and then it went all the way up to 15. So we decided we had to change something. That's not unreasonable, members of the jury. It was increasing. But then it went up to 75. It didn't just increase from 10 to 15 to 20 or to 25. It didn't just double or triple. It increased by 500%. And the negligent decision the city made, the unreasonable action was not to react to that increase and not resume greasing the poles to get back up here. And that's not all you heard. You heard that when they did grease the poles, they didn't receive a single report of anyone getting hurt. But on the one game when they didn't grease the poles, a young fan lost his life. The Super Bowl was 2 weeks later. They had 2 weeks to make an adjustment and they failed to respond. They did the exact same thing again. Some people would call that the definition of insanity. All we needed to prove was that it was unreasonable. Because you heard from Miss Davidson herself. If there's grease on those poles, she wouldn't have climbed it. She wouldn't have gone up to the top. She wouldn't have fallen. We wouldn't be here in Sam would. But even if you believe that the decision not to grease the light post was reasonable, we showed you another dangerous condition the city created, the ladders. That what they did was they put small metal fences at the base of the pole, perfect to allow people to climb up it. Miss Davidson told you herself, with the fence there, it was easy. And what's more is they should have known that with people climbing the poles, if you put something metal at the base, someone could hit their head and get hurt. That's exactly what happened. They either knew that that could happen or should have known. And again, they failed to respond. That's what happened today. You heard from Miss Davidson that she fell on Sam and then Sam hit his face on the metal pole and then bled out. If the city doesn't put the post there, we wouldn't be here. And Sam would. But even if you believe that the decision not to grease the poles was reasonable, that the decision to put a fence at the base of the pole that people climb was reasonable, we showed you a third risk they knew about. The landing zones. You heard today that a city officer was right there, half a block away. You remember when I told you this story in opening statements, then we did the story again, and the director of public safety testified to him. He's watching Sam at the base of the pole. He's watching Lanny up top. He sees that Lanny is 18 feet above the ground, that there's someone right beneath Lanny and a metal fence there. Think of all the reasonable decisions he could have made. Maybe he could have gone over to Sam and told him, go away. Could have moved Sam out of the way, could have moved the metal fence, could have brought a ladder, but he didn't. The city gave Lanny a ladder to get up and decided not to give her a ladder down. The officer doesn't even go to the pole and say, stay where you are. Stay where you are, there's someone beneath you, there's a metal fence there, don't move. If the officer does, we wouldn't be here. But the officer does the exact opposite. Panics, runs to the base of the pole and says, get down now. And that's the decision that from this situation from dangerous into catastrophic. Because when the officer yells up, Lanny falls, slips, hits Sam, who hits his face on the metal fence that's still there. The metal fence the city put there and decided not to take away. If the city officials exercised at any point an ounce of common sense, we wouldn't be here in Sam Wood. But they didn't. Hold them responsible. I'm alive. Thank you.
Thank you, counsel. How much time remains for rebuttal?
41 seconds.
41 seconds. You can proceed.
Prior to my closing summation, would it be all right if I retrieve that exhibit from?
Of course.
And turn this around as well. May I proceed, Your Honor? Rules only work if followed. Rules exist to keep people safe, folks. When followed, they can prevent accidents, injuries, even death. But these rules only work if people actually follow them. If someone ignores the safety rule, even just once, they take a risk. Now, in today's case, the rule was simple. Don't climb the poles. There were announcements about it. There were fences around all those poles. Everyone knew it was against the rules. But the plaintiff's friend, Lady Davidson, broke that simple rule. When she climbed up that pole, she ignored the announcements. She ignored the fence around it. She ignored for common sense. And she climbed all the way up that pole and landed right on Mr. Farnsworth. So let's talk about why we're all here today. What you all have to decide in today's case and the role that safety rules play when you have to decide. Because if the rule in this case were followed, we wouldn't be in the schoolroom right now. See, I know that it's natural when a tragedy like this occurs, I want to point fingers or find out who's responsible. But the law still imposes a burden of proof on the party that brings a claim. See, the plaintiff, they still have to prove to you that the city of Philadelphia breached their duty of care to Mr. Farnsworth. And that breach of duty was a substantial factor in his death. But they failed to meet that burden today. So let's discuss what Mr. McDonald is actually trying to argue. You see, because he just stood up here and everything he was telling you was hypothetical. You see, he's trying to argue that maybe if the city acted differently, there might have been a chance that Mr. Farnsworth would be alive. Maybe if there were grease, this never would have happened. But folks, that's not more likely than not. It's a little more than a guess. And what we do know definitively is that if Miss Davidson didn't decide to climb that pole, this never would have happened. But we'll get to that more in a moment, because when you're trying to decide that first question on your verdict form of whether or not the city of Philadelphia is liable, you're going to have to ask yourself what a reasonable city is supposed to do, what the reasonable conduct should be. And to answer that question, we showed you, to answer that question, you have to keep in mind that there were no rules or laws or regulations at all that said that the city of Philadelphia had to grease those poles. In fact, Director Edwards testified today and told you that greasing the poles didn't work. People would still find a way to climb. And so the city decided to try something new. They decided to put fences around all the poles, and I can't help but notice Mr. McDonald keeps calling these landing zones, but these only become landing zones if someone decides to climb to the top. If you stay on the sidewalk like a pedestrian is supposed to, that's not a landing zone. It's a fenced off area, and fences are a pretty clear indication you're not supposed to go near the pole, folks. But not only that, but you also heard it, they put announcements all over the place telling people it was against the rules. But even if they made all these rules clear, and even if they put fences all around them, these rules and precautions only work if the fans actually listen to them. Now, I want to be really clear. After you heard from the plaintiff, you got to hear from us, the defense. And while I don't think the evidence supports a finding of negligence against the city of Philadelphia, even if you do, your job's not over yet. Even if you do, your job's not over yet. You see, because the law still requires you to consider Miss Davidson's own negligence to that of the city of Philadelphia. And if you find that Miss Davidson's negligence was a greater factor in Mr. Farnsworth's death, then the result is that the city would be not responsible. Which makes sense, doesn't it? If it's Miss Davidson's fault that Mr. Farnsworth is dead, why would the city be held responsible? And what we showed you in court today wasn't guesswork, it was definitive. Rules only work if followed. At the beginning of today's trial, I asked you to keep in mind 3 key facts. First is that the city was abundantly clear that you shouldn't be climbing those poles. The second was that Lady Davidson knew that climbing those poles was dangerous and decided to do it anyways. And third, that's why Mr. Farnsworth died. Let's start with that first. That the city made it abundantly clear that you shouldn't be climbing those poles. You see, the director of public safety, Walker Edwards, told you himself that they put announcements out everywhere. And you saw one in court today. Straight from the mayor of Philadelphia. Attention, don't climb those poles. It's clear as day, folks. Everyone knew it was against the rules. Which brings me to my second point. That despite knowing it was against the rules and despite knowing it was dangerous, Lady Davidson still decided to climb that pole. Now, you heard in court today that Lady Davidson was well aware that someone had just died 14 days prior climbing the pole. And despite the fact that she knew that, and despite the fact she thought it was crazy, and she thought it was stupid, she decided to climb to the top of that pole. Which brings me to my third point. That's why Mr. Farnsworth died. Now, this one is easy, folks. Both parties agree that Sam Farnsworth died because Lady Davidson fell off the top of that 18-foot high pole and landed directly on top. Now, all of this could have been avoided if Lady Davidson just followed the rules and never climbed that pole in the first place. Now, I know that it's been a long trial, folks. So I want to thank you for all your time and attention throughout the entire thing. See, the plaintiff, they want you to believe that the city should have done more, should have put more grease on the poles or maybe had more signage, but the fact remains that the city made it adamantly clear you shouldn't climb those poles. Lady Davidson knew it was dangerous, but did it anyways. And 3, that's why Sam Farnsworth died. This accident happened because Lady Davidson didn't follow the rules. The rules, they only work if followed. Find the defendant not liable. Thank you.
Have a seat.
You may.
Counsel's right that this case comes down to decisions. Which is why when you go back to deliberate, I want you to remember 2 of the decisions. First, not to grease the poles. Counsel says that greasing the poles was effective. That only works once he turns the statistics around. The second decision I want you to remember is what they actually did do. They posted to Instagram, hoping that the millions of people in the Philadelphia area would see it. That's not enough, members of the jury. You heard they received report after report of people climbing, posting to Instagram, hoping that these people will see it. Just doesn't cut it. They created the risks that caused the harm. I'm liable. Thank you.
Thank you, counsel. Before you submit your ballots, I think we can all give these advocates and witnesses a round of applause. So I'll ask you all to submit your ballots.